Okay, so thank you so much for joining us today for our Community Legal Centres Queensland webinar for this week. My name is Carly Hanson and I'm one of the Sector Sustainability Coordinators here at CLCQ. I'd firstly like to acknowledge the traditional owners of the land on which we're holding today's webinar. In Meanjin, Brisbane, they are the Turrbal and the Yagara people. I wish to pay my deep respects to elders past and present and acknowledge that these are stolen lands and that sovereignty was never ceded. As today's webinar is being viewed by people across Queensland and Australia, I also pay my respects to the traditional owners throughout the country and extend a very warm welcome to any First Nations people who are joining us in today. So today's webinar is on gender discrimination and sexual harassment in the workplace. And I'll hand over to our presenters from Basic Rights Queensland's Working Women's Centre in just a moment. But before I do that, I'll just go through a couple of small housekeeping items. So today's webinar is being recorded and we'll have the recording available to download later today or tomorrow. The PowerPoints have been emailed out to everyone who registered about half an hour ago, and they're also available to download from our website and from the handout section of the GoToWebinar control panel. We do encourage you to ask questions, so you can type your question into the question box and we'll read that out at the end of the presentation because there is a fair amount of content to get through today. So I'll now hand over to our presenters, Jill, Megan and Ellie from the Working Women's Queensland office. And we'll start things off with Jill. Thank you, Jill.
Thank you, Carly. Thanks for having us. Just today we'll work on gender discrimination and sexual harassment in the workplace. Again, we would just like to acknowledge country at Working Women's Queensland and Basic Rights. We acknowledge and respect the traditional custodians of the lands where this training takes place, wherever you are. And we pay our respect to their spiritual relationship with country and acknowledge that sovereignty was never ceded. Just wanted to flag with those who are joining us today that talking about sexual harassment, sexual assault or any of these, or gender discrimination could be a real surprise for people, particularly thinking about past experiences or a current situation. Throughout this space, we will also be talking about a case study as well, and then there'll be an opportunity for questions online. What that means is that there will be some spaces where there's some unpredictable content as well. Obviously, we'll do everything that we can to keep everyone safe. Just letting you know that you can tap out of this at any time. You can watch the recording at another time at your own pace. And in that way, you can control what you consume, where you could skip over slides if you weren't interested or fast forward. At the end of this session, please do take a moment and reflect and sit for a while before getting back into your work if you can feel something, or you have a memory, or you're thinking about things in a different way. And remember, if you are a member of CLCQ, of course, you can contact your EAP and of course call 1-800-RESPECT. Working Women's Queensland, we are a service that works for and on behalf of people identifying as women. Talking about sexual harassment and gender discrimination, it's incredibly important that we acknowledge that the LGBTQI+ community have endured and continue to endure endless sexual harassment and discrimination, and just acknowledging that as part of our presentation today. We'd also take a moment to acknowledge that some men have also experienced sexual harassment. Our focus today, we're funded to work for and on behalf of women, and that will be our focus. We will be talking today about the drivers and the effect of gender discrimination and workplace sexual harassment in our community. We'll have a brief overview of the Respect at Work report that was released in 2020, and we'll also have a conversation about how things have gone 3 years on. We'll outline the implications as a result and also look at some legislative changes such as the Anti-Discrimination Human Rights Legislation Amendment Act, otherwise known as the Respect at Work Bill. And we'll also make some suggestions about what we can all do to improve safety at work. And finally, and within that context, we'll be providing an understanding of positive duty obligations for employers and how we can provide safe workplaces for everybody. Just so everyone's aware, this is not to be interpreted as legal advice. This session is information only. So who are we? Working Women's Queensland is a part of Basic Rights Queensland. We're a statewide, free, practical, confidential and supportive service to help disadvantaged women seeking help with work matters. We're a feminist service and we're focused on trauma-informed practice. As part of Basic Rights, you'll know that we also have our Social Security and Disability Discrimination team, as well as our Mental Health Legal Hub. A little bit more about who we are. We're a team of women, a multidisciplinary team of solicitors, of industrial officers and social workers. And we're really focusing on employment law and support of women in the workforce around domestic and family violence at work, discrimination, gender discrimination, sexual harassment, parental leave, flexible work arrangements, terms and conditions of employment, gender equity, general protections and workplace bullying. We receive funding from a few different sources, and I'd also acknowledge that in our work on gender discrimination and sexual harassment that we partner with Caxton Legal Service, and just acknowledge our connection there as well as Basic Rights Queensland. I'll also tell you a little bit about her story. So Working Women's Centres have been in existence in Australia for about 30 years, running as a community-based entities. There are 3 remaining Working Women's Centres, one in South Australia, one in Queensland and one in the Northern Territory. Previously, we were known as Queensland Working Women's Service and merged into Basic Rights in 2015. But the content and the nature of the work and the approach has began in Queensland in 1994. So it's a long history in Queensland. We've had intermittent funding. For the context of WWQ, this is a story of survival, of being absolutely focused into providing workplace and industrial advice to women and advocating for equality through employment. I know that there will be many women and people in this community sector who have had engagement with Queensland Working Women's Service, either on board or maybe they've connected around a range of things. So really just extending and acknowledging that in the CLCQ sector that we're pretty much connected well together and we all have a relationship at some place. Significantly, with our sisters in the other Working Women's Centres nationally, is that we have worked really hard on getting legislative changes about flexible work arrangements. Really pleased to see paid domestic and family violence leave. That was a piece of work that really started 20 odd years ago in this space for the Working Women's Centres. And now finally we've got some breakthrough around sexual harassment and gender discrimination. Being really clear, I'm not saying that that has been, that outcome isn't just about Working Women's Centres, but just acknowledging the contribution to where we are. Have a little razz about why does workplace equality matter? So while progress has been made, we need to recognise that women's economic security is absolutely linked to workplace gender equality. When there are barriers to women being able to access opportunities through financial independence, so many other areas of women's equality falls away. So this affects the full participation of women in civil society, reduces our choice and opportunity for all women. This also connects to escaping violence or property ownership, etc. Quite simply, when we're working into a place of sexual harassment and gender discrimination, what we're saying is that harassment's no longer acceptable at work. We're very clearly saying that employers must provide workers with paid domestic and family violence leave and support we're saying that harassment is no longer acceptable in our community and violence is no longer accepted in our homes. Specifically, I mean gendered violence. Briefly, we'll have an overview of our gender equality scorecard. This is a snapshot. I really encourage you to take some time and have a look about workplace gender equality. But we'll have a look, and it says that more than half of all Australians work in an industry dominated by one gender, and it hasn't changed since 2018. So you think about the CLCQ sector, we know that that's predominantly dominated by women, whereas other industries, perhaps such as construction, male-dominated. 42% of women work full-time compared to just 67% of women. Now that's really an important statistic when you think about wealth security and long-term superannuation, etc. So this workplace is so important in terms of independence and freedom for women. 22.3% of women are CEOs are women. So that's in leadership, that less than a quarter of women are into significant roles of leadership in Australian workplaces. What a missed opportunity. And only 1 in 5 boards in Australia have a gender balance. So really what we're talking about is that in Australian workplaces, women aren't getting as fair a go, if you like, and they're not getting the same opportunity in terms of their capacity around freedom and choice, which is why improving women's experiences of work is integral. So today we are talking about sexual harassment. So I'm very eager right at the very beginning to share with you a definition that's useful. And then the rest of our the presentation can really hinge on from there. So sexual harassment means any unwelcome sexual behaviour that a reasonable person could anticipate may make another person feel offended, intimidated, or humiliated in that situation. So unwelcome behaviour means unwanted or uninvited behaviour that makes a person feel offended, embarrassed, or frightened. Whether that behaviour is unwelcome is a question for the person that's harassed. The harasser's intent is not relevant. And a reasonable person could be taken to mean a neutral or unbiased observer. Sexual harassment is not always obvious. There's a wide range of behaviours that sit within that. The most common behaviours that you might see is sexually suggestive comments or jokes that offend or intimidate, intrusive questions about a person's private life or physical appearance, inappropriate staring or leering, inappropriate welcome, hugging, cornering, or kissing. So there's some common kind of spaces. Often we start talking about sexual harassment. This means that your mind will reflect on some of the interactions that you've either been on the receiving end of or observed or been around, and how perhaps if you are someone who's been in the workforce for a long time might reflect on how things have changed over time. Very much we're talking about 2023 and looking forward to what's acceptable in workplaces now. So other examples of sexual harassment also include sharing or threatening to share intimate images or video without consent, repeated or inappropriate invitations to go out on dates, requests or pressure for sex or sexual acts, explicit gifs, images, videos, cartoons, drawings, photographs or jokes, actual or attempted rape or sexual assault, explicit comments made in person or in writing, or indecent messages, phone calls, emails, the use of emojis with sexual connotations, gestures, indecent exposure, or inappropriate displays of the body. And sexual harassment can happen in person, over the phone, online, and as well, including social media. One of the really promising places that we've moved to around sexual harassment in the last 3 years is the Respect at Work report released by the Australian Human Rights Commission. Kate Jenkins at the time was Australia's Sex Discrimination Commissioner, and she has played a pivotal role in the creation of the Respect at Work report. She led the development of the report after growing concerns about sexual harassment in Australian workplaces. She initiated the National Inquiry into Sexual Harassment in the Workplace in 2018 and exposed the prevalence and nature of sexual harassment in Australian workplaces, the effect of the current legal and regulatory frameworks that were preventing action or change in the community, and looking at the adequacy of workplace policies and practices to address sexual harassment. The inquiry involved extensive consultations with various stakeholders, including individuals, organisations, experts and advocacy groups. In the context of that, let's draw our minds to thinking about what's happened over the last decade or more, some very recent more so, and really some quite exciting times. In the very beginning, there was the Me Too movement, started in 2006, but really rounding out in terms of its momentum, probably around 2013 and forward again. You might remember all the way back, if you're as old as I am, to 2017. So this was just after Trump's inauguration, and around the world, women started to stand up and say, actually, this type of discrimination, harassment at work, to assault at work is no longer okay. 2018, you can see then, we know that Kate Jenkins started her landmark inquiry in 2018 into sexual harassment in Australian workplaces. And I will just draw our attention to Brittany Higgins in 2021 and her experiences in Parliament House, which really draw a very sharp spotlight that if someone working in our supposed house of honourable people has been sexually harassed, assaulted in the workplace, which kind of spawned straight out of the Respect at Work report landing in 2020, looking at what Brittany's experiences, her experience there, and then steamrolling us across into March 2021 and the March for Justice and those type of spaces as well. So just connecting you into where we are in time and your connection that we're living in history, if you like, and there's opportunity for remarkable change for women in workplaces. So what did Kate Jenkins find out? What did the Human Rights Commission find out? No one will be surprised in the CLCQ sector that it's intersectional. So we have young workers experiencing sexual harassment at an intense rate. At 45% of young workers have experienced sexual harassment. Workers with a disability, Aboriginal and Torres Strait Islander workers at 53%. Our LGBTQI workers as well at 52%, as well as our workers from culturally and linguistically diverse backgrounds experience high levels of sexual harassment, as well as compounded by precarious and insecure work arrangements and also visa arrangements as well. 1 in 3 people have experienced sexual harassment in the previous 5 years. Wow, that's an amazing stat when you think about what that means in everyone's workplace. In 79% of the incidents, the harasser was a man, and the harasser was most commonly a co-worker employed at the same level. This certainly sparked a conversation with Ellie and Megan today. We were talking around that in terms of the nature of cases that come to us, often it has been the employer has been the harasser, and really talking about how perhaps in those instances when it's a superior is that you must act. When it's a co-worker, it really talks around how we encourage a change in our workplaces to say that it's not okay at any level, and it's not just that immediate impact. This will be of no surprise, I'm sure, to people, but it's, we do need to mention it, that will say workplace settings with a higher risk of sexual harassment are those that are in male-dominated industries. They have a high level of contact with third parties, customers, patients, or clients. So you could think about that in the context of perhaps hospitality and bar work. You might think about that in aged care. And what are the responsibilities in those workplaces to keep people safe. They're organised according to quite a hierarchical structure. They have a masculine workplace culture and often are isolated and remote. So that's those things about also considering Working Women's Queensland, we're a statewide service and we're always acutely aware of thinking about workers in those isolated workplaces and regionally and remote. Industries most at risk. Let's have a look at our information, our IT industry. 81% of people have experienced sexual harassment in that industry. Our artists and rec services at 49%, so thinking about our actors, our performers, our artists and their experiences. 47% in electricity, gas and water, our retail workers, our shop workers, and those in mining. 40% of workplace sexual harassment incidents were witnessed by at least one person at work. So someone has seen this and someone has either walked past it or allowed it to be acceptable. And then in 69%, the person that witnessed it didn't say anything. They didn't intervene at the time. Perhaps they have consoled someone after the case or validated what they saw, but they didn't intervene in the workplace and say, hey, that's not what we do here, or that's not what we say. And fewer than 1 in 5 people who experienced workplace sexual harassment made a formal report or complained about it because they were concerned about being the troublemaker, to being ostracised or ignored. And in the end, perhaps people have also chosen to resign. So what that means is when people aren't reporting, we don't get action, we don't get change. What you walk past is what you accept. The briefest summary of the Respect at Work report in 2020, the key findings were workplace sexual harassment is prevalent and it has severe impacts on individuals and organisations. There is a need for cultural change in Australia. We need prevention strategies and we need better support for our victims. The importance of holding employers accountable and their responsibility for addressing and preventing sexual harassment. So, the Respect at Work report had 55 recommendations, including introducing a positive duty on employers to prevent sexual harassment. It proposed strengthening our legal frameworks, defining sexual harassment, and removing certain legal barriers. From that space, one of the profound things and the transition that's happening at the moment in this law space is that the onus is being removed slowly from the victim and their responsibility to hold it all in the reporting of the instance and placing it back into the place of the responsibility of the employer and of the harasser. And it's also that her report is also calling for improved education training as well as increased awareness campaigns. If you have the opportunity, jump online and have a look at the Respect at Work website. And I want to let you know that in the Community Legal Centre sphere is that we have our very own recommendation. It says all Australian governments provide increase in recurrent funding to community legal centres and to provide legal advice and assistance to vulnerable workers who experience sexual harassment, taking into account the particular needs of workers facing intersectional discrimination. So absolutely in this space, really encouraging you to think about clients that are accessing your services and how their legal issues might be related to sexual harassment. The other thing is for working women's centres nationwide is that we have a recommendation that the Australian government increases recurrent funding to working women's centres and provide info and advice. We haven't received funding just yet. There's $24 million allocated over 3 years in the 2022 federal budget, there has been no movement on getting that money out into the sector. So that would be $8 million per year. We're not quite sure exactly where all the $8 million for this year has gone, but we certainly have been active in pursuing an outcome with our sister organisations. But I wanted to let you know that on the 28th of November 2022, the landmark piece of legislation, the Anti-Discrimination Human Rights Legislation Amendment Bill, the Respect at Work Bill, passed. And so that cartoon is absolutely real life caricature of Working Women's Queensland on that day. I'm going to pass you over to our Principal Solicitor, Megan Inglis. She's an outstanding lawyer. We're lucky to have her here working with us at WWQ. And she'll spend some time, talking about the law.
Thank you, Jill. So just moving on then, looking at the legislation, we can say that there are 6 outstanding legislative changes. The first one being a positive duty on employers. So the Act introduces a positive duty on employers to take reasonable steps to prevent workplace sexual harassment. And what that means then is that the employers have a legal obligation to proactively address and prevent sexual harassment within their organisations. There's the expanded definition of sexual harassment. So the definition has been broadened to include a wider range of behaviours and contexts. That ensures that various forms of unwelcome conduct, both physical and verbal, can be recognised and addressed under the law. Extensions to time limits, which is incredibly important when you're talking to clients. Time limit for making a complaint of sexual harassment to the Australian Human Rights Commission has been increased from 6 months to 24 months, so allowing more time to come forward and seek that redress for incidents. The next one is regulatory powers. So if we look at the powers of the Australian Human Rights Commission to handle those complaints related to harassment, granting the Commission the authority to intervene, investigate, conciliate and enforce the compliance of the legislation. Training and education, emphasising the importance of education and training in preventing sexual harassment, requiring employers to provide those training programs to their employees, focusing on promoting respectful behaviour, preventing sexual harassment and addressing the complaints in an effective way. And finally, privacy and confidentiality. So strengthening the privacy and confidential protections for individuals involved in those complaints, ensuring that the information that is shared during the complaint process is handled securely and confidentially. Some additional legislative changes rolling on from that then, amendments to the Sex Discrimination Act 1984, including definitions for workers and persons conducting a business or undertaking. What that means is that those protections are extended to all paid and unpaid workers, including volunteers, interns and self-employed persons in that space. Then if we look at the Fair Work Act, Secure Jobs and Better Pay Amendment Act from 2022, running through a number of the changes there, sexual harassment specific, compassionate leave, family and domestic violence leave, gender equity, equal remuneration, pay equity, expert panel. Pay secrecy is an issue as well, addition of further protection, protected attributes, flexible work arrangements with the Fair Work Commission having the power to determine disputes, and increasing cap and the advertising of employment at the rate of pay. Then also the amendments to the Fair Work Act in relation to sexual harassment, so section 527D, prohibiting sexual harassment in connection with work. A person, and this is obviously taken straight from the Act, the first person must not sexually harass another person who is a worker in a business or undertaking, or is seeking to become a worker in a particular business or undertaking, a person conducting a business or undertaking, if the harassment occurs in connection with the second person being a person of the kind mentioned in the first paragraph. And that, an important point, commenced on the 6th of March 2023, which is very recent. It's a new jurisdiction in the Fair Work Commission, not fully tested yet. We have an eye on test cases and we'll be very interested to see any developments in relation to compensation and outcomes. Amendments to the Fair Work Act in terms of vicarious liability. So employers can be vicariously liable for the actions of employees and their agents. They will not be vicariously liable if they prove that they took all reasonable steps to prevent the employee or agent from sexually harassing another person. What does that mean? Anti-Discrimination Human Rights Legislation Amendment Respect at Work Act amends the Sex Discrimination Act in 1984 to impose a positive duty on employers to take reasonable and proportionate measures. Why is this important? Because if employers don't do it, they might be held vicariously liable. I'm going to hand back to Jill.
Thanks, Megan. Well, one of our pathways forward is that how do we make the change? How do you make a change in your workplace? Or when you're talking with your family, your loved ones, your kids, if you are, as we were talking about this morning preparing for our webinar, if you are a group of women sitting around having lunch and people start telling their stories of sexual harassment and gender discrimination, you knowing this information is the opportunity to start changing our community and our society. The other thing is that in your workplace you can do something about it, and also think about this in the context if you are working with clients about what their experience has been, and knowing that when someone is coming to you with an experience of harassment and discrimination, then that's really seeing an opportunity there for you to say, actually, I reckon you should seek some legal advice about what's happened here. So one of the, we're thinking about a gender driver in a workplace. So we want to challenge the condoning of sexual harassment in Australian workplace, challenging attitudes and challenging discrimination. So no longer excusing, justifying, trivialising. We'll all enjoy this in the CLCQ sector, you know, a snowflake, you're too woke, you know, we can't have fun at work anymore. No, that's not acceptable anymore. We're going to challenge discrimination. We have a responsibility to recognise and challenge discrimination of all, in all areas, on gender, on race, on sexuality, disability, and other discriminatory attitudes. What we can do is we should all be immediately reviewing our policy, conducting a review of our policies and procedures to see if we're condoning sexual harassment in the workplace, talking about it. Like any issue, as we know in the CLCQ sector, is that we want to be shining a light and creating opportunities for worker to discuss workplace culture. What's the place that people want to work in? How do they want to feel when they come to work? And also ensuring that our workforce understands what behaviours and actions constitute sexual harassment. We want to promote women's independence and decision-making in the workplace. Perhaps your organisation or a business that you're thinking about actually does need to set a gender equity target. Promoting independence. So that's about recognising and promoting the achievements of women in the workplace and creating pathways and opportunities for women to lead. Think back to that slide right at the very beginning when we talked about how many women are in leadership roles in Australia as identified by the Respect at Work report. It was less than 25% of women were CEOs in Australia. Only 1 in 5 boards in Australia had gender balance. We also encourage you to review workplace settings, conduct an audit, discover the workplace characteristics. How does male-dominated culture exist? One of my favourites is observing who speaks up in our meetings. Who is the person that echoes or has permission to speak? Is it the male voice that often speaks more often in your team meetings? And identifying how you might facilitate a process to make sure a different voice is heard in those collaborative meetings. And inform your workplace. So that's about saying this is the standard that we want. Talk about it with people, involve them. We want to build cultures that foster personal identities that are not constrained by rigid gender stereotypes. Let's free everyone up from that space. So consider the roles that people have and how they're creating power imbalance. Challenge the way that things are just done that way around here, or that's just them. They always do it that way. It's absolutely okay to recognise workplace habits that could have been based on gender, and that this could be less about gender and more just about the individual. And that's really important in male-dominated workplace to have a think about that. Recognise disrespect. So educate and support leaders to recognise that when disrespect happens in the workplace. And looking at the microaggressions, if you prefer, that happen that can go unchecked, that show disrespect towards women or people of diverse gender. Encourage speaking up. Make it clear that you encourage someone to stand up for someone else. That's a culture, a place that you want to hear about. Hearing a different experience or story is critical in your workplace. And we also want to support non-traditional roles. Plan and support different workplace roles and models that everyone gets an opportunity. So that's about thinking about how you might even assign, when do you do your team meetings? Is it at 3 p.m. in the afternoon, and those with children can never attend? Those type of experiences. We also want to support men in developing healthy masculinities, positive and supportive male-peer relationships. I am a proud parent of 2 adult men, and absolutely encourage the development of healthy masculinity. And about allowing all genders the opportunity to express themselves, to be soft and firm as they need to, whatever people need to be. So we want to provide education, and we want to challenge gender bias. We're going to support mentoring for leaders and encourage healthy and positive relationships in the workplace. We're going to recognise achievements of everybody and work towards a positive workplace culture, and really rewarding those positive relationships and providing supportive networks for people. So really these slides, they do come from, they're lifted straight out of the National Human Rights Commission, their pieces of work, but I encourage you to really reflect and think about each one of us has an active change. So we're at the critical end of legislation when we're looking at where sexual harassment or gender discrimination that we may need to make a complaint. But there's so many preventative pieces that you can do around changing how our community and society works in these ways, but also just doubling back into positive duty, and that our workplaces are not what they were 5 years ago. That's not what they were 10 years ago. There's an expectation that all Australian workplaces provide safety and security for everyone at work from sexual harassment and gender discrimination. Work is all good until you get, it's all well and good to talk about law and reports, but the practical stuff is what brings meaning to us. So I'm going to bring us across to Ellie. She is, or Eloise Dalton on the slide, one of our exceptional solicitors at Working Women's Queensland, and she has been doing so much work in this area in the past little while, and has moving across from the previous system of sexual harassment and now moving into the new jurisdiction. So she's got some great case examples, excellent experience. If you need to reach out to either Ellie or Megan, please do. But I'm going to pass over to Ellie. She's going to talk about the case study.
Thanks, Jill. So we thought we'd share this case study as a showcase of the work we do at Working Women, and to show you how we walk the talk. So this particular case, a client was referred to us from the Fair Work Commission as part of their workplace advice service. We provide services through that workplace advice service. This particular client, she wasn't a member of a union, and she didn't have any knowledge of unions. She didn't have financial means to access legal advice if it wasn't through a free advice service. English was her second language, and she was in Australia on a working holiday visa. So we highlight that to really show that she would have fallen through the gaps if it wasn't for our service. Unfortunately, she had experienced sexual harassment from her supervisor at work. She was working in a regional setting. She had tried to resolve that complaint herself internally, and the supervisor and employer had been quite dismissive and had disregarded her complaint. So she came to us for advice, and we walked her through her options and how she might wish to resolve it. In the end, we assisted this client to make a complaint. Ultimately, that complaint was prioritised through the system as a result of our advocacy, and we were able to assist this client to reach a resolution through a conciliation process. And as a result, she was able to achieve compensation, but there were also some non-monetary terms that really left a great legacy in that workplace. She was able to ensure that the employer and any staff there undertook mandatory workplace sexual harassment training, and also that the employer implemented a policy that addressed workplace sexual harassment and anti-discrimination. So it was a really fantastic outcome, and we were really proud. And I just note there that we worked with different services, including TIS National, so that there was an interpreter every step of the way, and also we're able to refer to different services so the client got the support she needed.
Perfect, Ellie. That's really a very interesting case, that's for sure. One of the things that's so important that I'll reiterate on behalf of our team is, and for you thinking about, is please complain. Please expect something better in our workplaces. Use this legislation, test it, encourage people to reach out around what's happening in their workplace, and because we want to be part of this no longer being acceptable. We have some time for questions. I'm going to pass over to Carly, who is helping to moderate questions from people at home, if you have any.
Thank you so much, everyone. That was a fabulous presentation and very thorough, and a great case study as well to share how this legislation would operate in practice. So just a reminder, you can ask your questions by typing those into the questions box on the GoToWebinar control panel. So while you're doing that, there was a question that came through from someone who registered. So I might just read that out. I'm not sure whether this group of people are able to answer it. I'm sure that hopefully there'll be some good comments and suggestions. So the question was, this person was wondering what might be, or what is being done in workplaces to ensure the psychological safety of lawyers with pre-existing trauma conditions and other experiences. So this is about the workers in our workplaces. So I just wondered if you had any reflections on that. I'm not a lawyer, so one of the things that have been sitting parallel to some of the changes in the Fair Work Act, but also in terms of work-safe legislation, is I would explore people to have a look at what psychosocial hazards are, and that to explore through that. There is obviously a complete encouragement for people to look after themselves well. I couldn't possibly comment on people's previous work experiences or experiences coming into the work. What I will say, after I've worked for 25 years in the community sector, around in trauma practice in places where people have experienced violence, and as we move into some more enhancements of lived experience, is that there is a responsibility on employees to make sure that we keep our workers safe, and also there's opportunities for people that have had significant experiences before coming into this line of work, to find a safe place for them so we get the best of that lived experience knowledge coming into our industry, and we get the best out of people without hurting people.
I might jump in and say, if the question is looking for some specific examples, Workplace Health and Safety Queensland obviously have their code of practice about managing the risk of psychosocial hazards at work. There are some fantastic points that are raised in that code of practice, so they might be a great place for the questioner to start. But then, of course, if they're looking for some specific advice, reach out to a service that is available, because it'll be tailored depending on your particular needs.
Thank you. And for everyone who regularly watches our webinars, you might have noticed that we ran a webinar with Maurice Blackburn very recently on the psychosocial hazards and the changes to those workplace health and safety laws in Queensland, and covered that code of practice. So that might be a good place for you to also check out. Don't have any other questions coming in just yet, but I can see that Marie, you've got your hand up. So I am happy to unmute you if you would like to ask your question. Oh no, the hand has gone down. Might have been an accident, that's fine. So yeah, now's a good chance if you do want to ask any questions about what these changes might, how these changes might operate, or what's happening in your workplace currently. But while you're doing that, I might just ask another question of our presenters while we've got them in the room. So are there any, does Working Women Queensland and Basic Rights Queensland have any templates or helpful information on the website perhaps that people could source and have a look at?
Yeah, there's definitely some fact sheets on our Working Women's page at Basic Rights Queensland, and we're actively, madly updating them. We've been in a place of limited funding up until this year, so you can imagine behind the scenes, we have been working really hard to refresh them, and they should be up within the next week. So that's good. I have an interesting spot that I think maybe Ellie can talk to well in this space. Is, Ellie, can you talk about when women are inquiring about whether they have a complaint? So when you do an advice call or a WAS appointment, do you think that women generally have an understanding that it is sexual harassment? What's the experience of them coming?
I think yes, Jill. I think most of the time when people reach out to us, they've done a bit of homework themselves. They might have even made a complaint internally, and they're really looking to what they can do next. So I'd say yes, but perhaps some of the conduct that did rise to sexual harassment, that wasn't something that they canvassed. They just took the most serious conduct, and that's what they were acting on. And it's our job to really canvass each of those incidences and say, well, that was sexual harassment too.
So as we know in other areas of violence, and I don't mean to, I'm not drawing a straight line here in any way, but say coercive control and how that kind of moves into more extreme experience, or not more extreme, so I don't mean to minimise that at all, but it is an indicator of imminent violence around in domestic and family violence. I'm just wondering if where Respect at Work is saying that we want safe workplaces, some of those smaller instances that lead up to I need to make a complaint, this is intolerable anymore.
Yeah, that's right. There's lots of those. It seems to be a cumulative impact. There seems to be lots of issues when somebody feels brave enough or empowered enough to speak up. They often have been putting up with this conduct for many months, which is obviously quite awful. On the question of resources as well, I might just jump in and add that the Respect at Work website have a fantastic good practice framework for preventing and responding to workplace sexual harassment. So that's something available for organisations. They've got loads of great resources on that website to check out.
Thank you. So while you've been speaking, a couple more questions have come in. So I'm curious about whether you've got any, I guess, practical examples or tips on what workplaces can do to meet this new positive obligation beyond, you know, sexual harassment training.
Absolutely, it's Megan here. I'll just say that probably the most important thing to consider, and I suppose it probably also touches on that question around what are workplaces doing for lawyers who are who've experienced some vicarious trauma in these sorts of situations, is to make sure that the organisation that you're working in has a policy around these issues and follows through with the training as well. So that is obviously going to be the most key point in preventing these sorts of situations from arising in the first place, but obviously also creates a point of reference for handling those sorts of concerns when they're raised.
Thank you. There are a couple of questions that have also come in, just sort of wanting to pinpoint exactly what sorts of relationships are covered in terms of employer-employee relationships. So would it include, for example, a member of a board or management committee of an organisation? So I think earlier there was a mention that that had been expanded. So can you talk a bit more about that? And, this person is asking whether it's similar to the relationships or the broader employer relationships like PCBUs and work health and safety laws.
I think we just comment and say yes, the expansion to the definition is fantastic. It encompasses many more people, which is great. So yes, that would be included in those changes.
And that was just a bit of a clarification to that question, which is, I guess board members, clear, often they are volunteers, but sometimes they're also paid, so that's covered. And would a subcontractor or an independent contractor also be covered?
We would say yes under those circumstances. So the expanded definition would allow for a much broader scope in terms of who would be covered under the legislation.
Thank you. Yeah, great. Hopefully that answers the questions there. Thank you.
And self-employed people as well. So that's something that we. Yeah.
Excellent.
Again, sorry, just to jump in, the good practice indicators in that framework specifically deals with leadership positions and boards. So if that questioner was looking for some resources, I'd definitely refer them there.
Wonderful. And if a workplace doesn't meet that obligation, what are the sorts of penalties that might be available or applicable? And would this only occur after an individual has made a formal complaint, or would it include other circumstances?
It does depend. Of course, we frequently see this issue cropping up when somebody does make a complaint, and the question arises of whether we can hold the employer vicariously liable for the conduct, and if they did take all reasonable steps. Outcomes, honestly, the answer is it depends, but there could be compensation payable. You heard in our previous example that this particular employer agreed that they would then implement mandatory training and update their policy. So vicarious liability is really the answer to that question. That's the incentive to meet your obligations.
The legislation is new as well.
Yeah, I can just expand on that a little bit as well. Just so if we think about vicarious liability, under Fair Work, we would say an employee or agent of the person, the principal, does in connection with the employment of the employee or with the duties of the agent as an agent. It's very wordy, but if you want to drill down on that, we can probably provide an additional slide with some extra information. For Queensland, a person's workers or agents contravenes the act in the course of work or while acting as an agent. And where an employee or agent of a person does in connection with the employment of the employee or with the duties of the agent as an agent. So when we're talking about an agent, I guess we're talking about anybody who is in that position in relation to employment and the conduct of work. moving on from that, how to avoid the vicarious liability. It doesn't apply if the principal proves that the principal took all reasonable steps to prevent the employee or agent from doing acts. If the respondent proves that they took reasonable steps to prevent the worker or agent contravening the act, or it doesn't apply if the person established that the person took all reasonable steps. So again, it creates that positive, the vicarious liability creates the positive duty on the employer, and with that expanded definition. The simplest way to address it is to have those policies in place. Ensure that your employees or your entire organisation has that training, and that you know, that they step in and actually to create that positive workplace experience for all people in the conduct of work.
Wonderful. Thank you so much. I think that's all the formal questions that we've got at the moment, which takes us almost to time. I just had one final question, which again you might not know the answer to this yet, but just wondering whether in Queensland this also might give rise to a human rights complaint.
Yes, the answer is yes. If there's been some sexual harassment, it may be possible to make a complaint to the Queensland Human Rights Commission under the Anti-Discrimination Act there. We do assist our clients with complaints in that jurisdiction. It is a great jurisdiction for clients to be in, so short answer, yes.
Wonderful. All right, we'll watch this space, and thank you again to our fabulous presenters, Jill, Megan and Ellie. And over to you if there's any last final words you wanted to mention.
The last part that I'd really like to encourage the sector to have a look at is that obviously there's some links there, but you are all professional people, so I know that you'll be able to Google those resources as you need. Just a reminder that in the community legal in community sector, you could contact us at Working Women's Queensland. Caxton Legal Service, who we partner with, are certainly able to also assist with people who don't identify as women as well. And if you're stuck, always contact CLCQ. And just an encouragement that the Services Union is our union, and they provide legal advice and advocacy in this space. And just a reminder to join your union, get involved, be a part of that broader conversation, and also that individual support that you need. I really do want to double us back to that beginning conversation that at the end of today's session, you need to talk to someone. You can call 1-800-RESPECT. You can call BRISC, Brisbane Rape and Survivor Support Centre, and also Brave Hearts. Please take a time if you can. And of course, if you like, at the end of this session, have a cup of tea, get out into the winter sunshine for just a moment and reflect on the content today. It is, you know, heavy and light. Yeah, and of course we say thank you.
Thank you so much. That's a great note to end on, I think. So thank you also to all of our attendees on the line today and for your great questions. We will be closing up the webinar in just a moment, but a quick reminder to please complete the evaluation survey that will pop up on the screen when you do exit the webinar. The feedback is really helpful for us and for our presenters to know that hopefully we're hitting the mark, and for also any future ideas for webinars that you might have or training that you would need. So thanks again to our presenters and Working Women Queensland, and we will see you at the next Community Legal Centres Queensland webinar. Thanks so much, everyone. See you later.